Hi, this is Reverend George A. Lungay, a Juris Doctor student of the College of Law of the Holy Name University here in the city of Tagbilaran. So for today's presentation, I will be dealing with the assigned case with GR numbers 1992-84-85, GR number 1994-28, and GR number 1994-73, promulgated on October 13, 2021 with Jose S. Ramiscal Jr. versus People of the Philippines, Manuel C. Satuito versus People of the Philippines, and Perfecto O. Quilicot Jr. versus People of the Philippines. So accordingly, this involves with three consolidated petitions for review on certiorari under the Rule 45 of the Rules of Court. So according to the facts of this case, the petitioners Ramiscal, Satuito, and Quilicot were holding the positions of President, then Chief of Documentation of the Legal Division, and Project Officer, respectively, with these three petitioners of the Armed Forces of the Philippines Retirement Separation and Benefit System, or AFP-RSBS. So this AFP-RSBS was created by Presidential Decree number 361 in order to manage the retirement and pension funds of those in the military service. In 1996, the AFP-RSBS Board of Trustees undertook a Calamba land banking project, or so-called Calamba project, involving the acquisition of properties in Tanawan and Laurel in Batangas and in Calamba, Laguna, in a total area of about 600 hectares to be consolidated for the development of housing projects and other mixed-use developments. In furtherance of the project, accordingly, a Memorandum of Understanding, or MOU, was entered into between Vintage Builders Corporation, or VBC, as consolidator and AFP-RSBS as buyer. Now, the MOU provided in part that the purchase price for these consolidated parcels of land with an aggregate area of 600 hectares, more or less, shall be the average price of 225 pesos per square meter, which amount is guaranteed price that will be paid regardless of whatever price that may have been agreed upon by the consolidator and the respective land owners. Now, during the Investment Committee meeting on February 14, 1996, which attended by Ramiscal as President or Chairman and Quilicot as Project Officer, the proposal to acquire the 600 hectares offered by VBC was approved, and it was also clarified that the 225 pesos per square meter guaranteed price was not the selling price in all cases. The AFP-RSBS Executive Committee approved this arrangement on February 22, 1996, and the Board of Trustees also subsequently gave its approval on March 1996. On July 27, 1996, so in a meeting of the Board of Trustees attended by Ramiscal, the board approved a recommendation to redo the documentation of transactions involving the Calamba project in order to reflect the actual price paid for a parcel of land, instead of the average price of 225 pesos per square meter. So on September 11, 1996, AFP-RSBS and the consolidators agreed to a new arrangement in the manner of acquisition of lots and payment. One of the properties procured by the AFP-RSBS under the Calamba project was lot number 7055 in Tanawan, Batangas, subject to this case. Now, Glicerio, acting as attorney in fact for the other owners, executed a unilateral deed of absolute sale, or unilateral deed in favor of AFP-RSBS involving the said parcel of land, reflecting the price of 227,460. Now, this unilateral deed was later on cited in a certified true copy of the cancellation of the TCT in the name of the plazas. However, on April 23, 1997, AFP AFP-RSBS, represented by Ramiscal and Glycerio, executed a deed of absolute sale or bilateral deed over the same parcel of land for the price of 1,531,564 or 202 pesos per square meter. On the STF, Quilicot and Ramiscal affix their signatures indicating their approval thereof in their respective capacities. Now, in the Senate Blue Ribbon Committee, in a report dated December 23, 1998, found that there was irregularity in the Calamba project and recommended for or the prosecution of those responsible therefore. Subsequently, several informations were filed by the Office of the Ombudsman before the Sandiganbayan against the petitioners, along with the other officials of the AFP-RSBS. Now, subject to this instant case are criminal case numbers 28022 and 28023, which the Sandiganbayan decided for the violation of Section 3E of the Republic Act number 3019 and for staffa through falsification of public documents. In its decision, the Sandiganbayan found petitioners guilty beyond reasonable doubt of violation of Section 3E of RA number 3019, while it found only Ramiscal guilty beyond reasonable doubt of the lesser crime of falsification for public documents. On July 24, 2020, counsel for Ramiscal filed before the court a notice of death, attaching thereto a copy of Ramiscal's certificate of death with the date of death on July 17, 2019. The main issue of this case is for resolution of the court is the issue of whether the Sandiganbayan was correct in finding petitioners guilty beyond reasonable doubt of the violations of RA Section 3E of RA number 2019. So the rulings of the court, accordingly, the court finds merit in the petition. Of course, with the issues corresponding details with each petitioner. No? On the death of the petitioner Ramiscal, given that Ramiscal's death transpired while this case is pending resolution, his criminal liability was totally extinguished in view of Article 89 of the Revised Penal Code, which states how the criminal liability is totally extinguished, particularly in Article 89. Criminal liability, accordingly, is totally extinguished. First, by the death of the convict, or as to the personal penalties. And as to pecuniary penalties, liability therefore is extinguished only when the death of the offender occurs before final judgment. Furthermore, in Section 4, as to the death of the civil actions, the court shall forthwith order said legal representatives to appear and be substituted within the period of 30 days from notice. If the accused dies before arraignment, the case shall be dismissed without prejudice to any civil action the offended party may file against the state of the deceased. Hence, Ramiscal's civil liability ex delicto is likewise extinguished, and the GR numbers 1992, 84, 85 are hereby dismissed due to the death of Ramiscal. Now, second, the validity of the two deeds of absolute sale. The court notes that aside from the unilateral deed, the Sandiganbayan did not consider any piece of evidence in arriving specifically at the conclusion that the true purchase price was at 227,460. Notably, its faith in the unilateral deed is heavily anchored on presumption in law and the rules of evidence, or on evidence, on the regularity of the acts of the Register of Deeds, the due execution of notarized documents, and the credibility of witnesses. First, the Sandiganbayan's reliance on the CTC in the name of AFP-RSBS enrolling that the unilateral deed contains the true selling price is misplaced. For purpose of determining the accused guilt beyond reasonable doubt, the presumption cannot go so far as to vouch for the particulars of the agreement between the parties and the accuracy of details indicated in the document. Precisely because of the ministerial nature of the act of registration as well as the fact that registration was never meant to attest to the truth or accuracy of the contents of the document or deed on the basis of which a certificate of title to land is issued, the court finds it injudicious to hinge a finding of guilt beyond reasonable doubt thereon. Second, the Sandiganbayan's weighing of the two deeds of absolute sale within the framework of evidentiary weight of notarized documents is not in accord with logic, according to the court, evidentiary rules, and the evidence at hand. The court finds disturbing how the Sandiganbayan had clothed the unilateral deed with the infallibility using a loose wave of presumptions which lack footing in any other evidence on the record. Glicerio, the seller, took the witness stand as witness for the prosecution, and he unequivocally admitted that he received more than 1 million pesos as consideration for the sale of the subject property. Now, in this case, the court finds that the Sandiganbayan significantly erred in its appreciation not only in the testimony of Glicerio but also the rest of the material evidence presented by the prosecution. Moreover, the court emphasizes that Glicerio is a witness for prosecution. Despite being in the prosecution control, Glicerio still testified consistently in a manner which directly contradicted to the prosecution stance, and that the unilateral deed reflected the true purchase price for the subject land. The court strongly disapproves of the Sandiganbayan's finding. This is a strained and unreasonable reading of Rule 132, Section 34 of the Rules of Court. Without a doubt, this is grave abuse of discretion by the Sandiganbayan, which becomes even more glaring when the prosecution's offers of the serious testimony is considered. And told, the Sandiganbayan erred in finding that the unilateral deed contained the true understanding between AFP-RSBS and the seller, and the bilateral deed was void. As borne by the records, this have not been proven beyond reasonable doubt. Not all of the elements of the violation of Section 3E of RA number 3019 were proven beyond reasonable doubt. Evidently, the foregoing findings are based on the conclusion that the 227,460 as indicated in the unilateral deed is the true purchase price, and the 1,531,564 indicated in the bilateral deed is a fabricated purchase price. Hence, the element of undue injury has not been proven beyond reasonable doubt. It is settled in jurisprudence that the evident bad faith, quote-unquote, necessary for a conviction under Section 3E of RA number 3019 does not simply connote bad judgment, but also palpably and patently fraudulent and dishonest purpose to do moral obliquity and or conscious wrongdoing for some perverse motive or ill will. Time and again, the court has adhered to the rule to sustain a conviction. The prosecution must prove the guilt of the accused beyond reasonable doubt, relying on the strength of its own evidence and not banking on the weakness of the defense. Mere suspicion, no matter how strong, cannot sustain a conviction, and every reasonable doubt must be resolved in its accused's favor. Therefore, mindful to the overwhelming presumption of petitioner's innocence, they must be acquitted. Moreover, the acquittal of petitioners benefits co-accused who did not assail the Sandiganbayan's decision and resolution. The court notes that among those found guilty by the Sandiganbayans of violation of Section 3E of RA number 3019 was Ricky Billo, who was at the time of the facts involved in this case head of the legal division of AFP-RSBS. Given that Billo's supposed liability is anchored on the same erroneous findings of the Sandiganbayan, the acquittal of Quilicot and Satuito should also benefit to Billo, consistent with the foregoing rule. For, accordingly, in view of the foregoing, the court resolves to 1. Dismiss the case against petitioner Jose S. Ramiscal Jr. in view of his death, and 2. Grant the instant petition. Consequently, the petitioners Manuel C. Satuito, Perfecto Quilicot Jr., and Menrado Enrique Bello are acquitted of the crimes charged for failure of the prosecution to prove their guilt beyond reasonable doubt. So these are all about this case. Thank you very much.